the Death Penalty Project, the Kenya National Commission on Human Rights, the Kenya section of the International Commission of Jurists, the Legal Resources Foundation, and the Katiba Institute, as well as the Attorney General, were all admitted in this matter as amici curiae. The gravamen of the petitioner's appeal is that the mandatory death sentence imposed upon them and the commutation of that sentence by an administrative fiat to life imprisonment are both unconstitutional and therefore null and void. In the circumstances, the petitioners are entitled to damages, the quantum of which this court should assess. On the 3rd of March 2016, this court heard the appeals to completion and reserved their judgment for delivery at a later date. However, before the judgment could be delivered, a number of judges, former Chief Justice Mutunga, former Deputy Chief Justice Rawal, and Mr. Justice Tunoi, retired from the court, necessitating the hearing of the matter de novo before this bench. The petitioner's case, presented to us by Learned Counsel Ms. Angatia for the first petitioner and Mr. Kilukumi for the second petitioner, is that the mandatory nature of the death penalty under Section 204 of the Penal Code jettisons the discretion of the trial court, forcing it to hand down a sentence predetermined by the legislature, thus fouling the doctrine of separation of powers. They submitted that the sentencing process is part of the right to a fair trial enshrined in Article 50, Subarticle 2 of the Constitution. They contended that the mandatory death penalty under Section 204 of the Penal Code violated that right in that it denied the trial judge the discretion in sentencing. The petitioners further contended that Article 52Q of the Constitution entitles any person who has undergone a criminal trial to appeal or seek a review from a higher court. This includes a second appeal. However, as Section 261 of the Criminal Procedure Code limits second appeals to convictions only, if not set aside by the first appellate court, the mandatory nature of the death sentence violates the convict's rights to a fair hearing under Article 52Q of the Constitution. Besides, the petitioners relied on Articles 1, Subarticle 1, 1, Subarticle 3, 2, Subarticle 4, 19, Subarticle 3, 201, Subarticle 1, 25, 26, Subarticle 1, 27, Subarticle 1, 28, 29, 50, Subarticle 2, 159, Subarticle 1, 160, Subarticle 1. The petitioners relied on a number of authorities in case law, including the decision in Patrick Reyes against the Queen, 2002, to appeal cases 235, in support of their submissions. Like in this appeal, the Privy Council was called upon to consider the mandatory death sentence imposed on the appellant upon his conviction for the offense of murder. It unanimously quashed Reyes' death sentence. In reaching that conclusion, the Privy Council cited with approval the 1989 House of Lords Select Committee report on murder and life imprisonment, which had concluded that murders differ so greatly from each other, and as such it is wrong to prescribe the same punishment for all murders and the observation of the Inter-American Commission that the mandatory imposition of the death sentence is unconstitutional as it disregarded an offender's personal circumstances, thus robbing him of personal dignity. The Privy Council also referred to decisions of other courts. The first one was the U.S. Supreme Court decision in Woodson against the state of North Carolina, 1976, 428 U.S. 280, in which it had been held that a statute that prescribes a mandatory sentence on conviction has the effect of treating all persons convicted of a designated offense not as uniquely individual human beings, but as members of a faceless and differentiated mass to be subjected to the blind infliction of the death penalty. The second authority was another U.S. Supreme Court decision, Robertson against Louisiana, 1977, which declared a statute that prescribed the mandatory death penalty on conviction of certain classes of murder as unconstitutional. The third decision was that of the Indian Supreme Court in Mithu against the state of Punjab, 1983, which had held that a standardized mandatory death sentence that excludes the involvement of the judicial mind fails to take into account the facts and circumstances of each particular case and must therefore be stigmatized as arbitrary and oppressive. The petitioners also relied on the cases of Susan Kigula and for 416 others against the Attorney General, 2005, in which the Ugandan Supreme Court quashed the mandatory death penalty imposed upon the appellant in that case as unconstitutional and remitted the case to the High Court for resentencing, and the decision of the Constitutional Court of Malawi in Francis against Kafantayeni and 5 others against the Attorney General, 2007, that sentencing was a legal issue that formed part of the principle of fair trial and required judicial determination in the course of a trial and could not be achieved by a legislative fiat. In the circumstances, the imposition of the mandatory death sentence, which denied the convicted person an opportunity to seek review from a higher court, amounted to inhuman treatment or punishment. The petitioners, in further support of their arguments, cited the Court of Appeal decision in Godfrey Ngotho Mutiso versus R, 2008, in which the Court of Appeal appreciated that a uniform sentence deprives the court from considering mitigating circumstances and fails to appreciate that sometimes there may be unequal participation in a crime which would result in different charges and sentences in relation to the accused persons. The petitioners urged this court to overturn the Court of Appeal decision in Mwaura against Republic, 2008, that the death penalty is grounded in the Constitution as bad law. They urged this court to find that the appellate court grossly erred by failing to find that the mandatory nature of the death sentence set out in Section 204 of the Penal Code is unconstitutional. Contending that only a valid sentence in law can be commuted by the President of the Republic, counsel for the petitioners dismissed the commutation of the petitioner's death sentence to life imprisonment as untenable, given that the mandatory death sentence imposed upon them was unconstitutional. Consequent upon those findings, the petitioners prayed the mandatory death sentence, which has since been commuted to life imprisonment, be set aside and that they be set free. Also for a definite term of imprisonment subject to the applicable remission rules, that this be meted out to them, or alternatively an order be made remitting the matter to the High Court to undertake a sentence hearing for the purpose of determining an appropriate definite sentence. Describing their incarceration for 17 years in the segregated death row as agonizing, they urge this court to find that they are entitled to compensation for that unconstitutional detention and proceed to assess the quantum thereof. The petitioners did not stop there. They urge that this court's declaration that the mandatory death sentence prescribed by Section 204 of the Penal Code is unconstitutional and the consequent award of damages for that illegality should apply to all convicts suffering the same fate. Relying on the state's written submissions dated the 26th of February 2016, Learned Counsel Mr. Nderitu, for the Director of Public Prosecutions, the respondent submitted that, as is clear from Article 26 of the Constitution, the right to life is absolute. Under our penal code, the death penalty is a lawful, though not the only, sentence for the offenses of treason, oughting to commit a capital offense, murder, robbery with violence, and attempted robbery with violence. He, however, conceded that the mandatory aspect of such sentence is unconstitutional. He concurred with counsel for the petitioners that sentencing is a judicial function. As such, under the doctrine of separation of powers, the legislature ought not to encroach upon territory that constitutionally belongs to the judiciary. Counsel submitted that while conducting a trial, the court gathers valuable information relating to the guilt or innocence of an accused person. In the event of a conviction, such information should serve as mitigating or aggravating factors in the determination of an appropriate sentence in each case. Counsel for the respondent urged this court to be persuaded by the recent High Court decision in Joseph Kaberia Kahinga against the Attorney General, Constitutional Petition number 680 of 2010, which determined that it would amount to a violation of the accused person's right to fair trial as provided under Article 50, Sub-Article 2 of the Constitution, if the court does not receive and consider mitigating factors and other statutory and policy pre-sentencing requirements. In conclusion on that point, Mr. Nderitu once again concurred with counsel for the petitioners that the matter be referred back to the High Court for resentencing, where the petitioners will be accorded an opportunity to put their case across. The prosecution and the victims of the crime in this matter be fully heard. The time the appellants have spent in custody be taken into account in determining the appropriate sentence. He urged this court to set timelines for that hearing. Since the petitioners have not challenged their conviction by the High Court, Mr. Nderitu dismissed their claim for damages as baseless. In any event, he urged, the award for damages is a civil claim that demands a separate and distinct hearing. He termed as sweeping and totally untenable counsel for the petitioner's recommendation that the court's decision in this matter do apply to other convicts who are not appearing before it. Now, the first Amicus curiae, the first Amicus curiae, relied on their joint written submissions dated the 4th of February 2016. They submitted that the core issue in the present appeal is the compatibility of the mandatory death penalty with the Constitution, not the constitutionality of the death penalty itself. The latter having not been an issue in this appeal, they observed that the same should be left to another day and in an appropriate case. On Section 204 of the Penal Code, the Amicus Curiae submitted the mandatory aspect of the death penalty under that section is not only inimical to international law and customs, and hence fouling Articles 2, 5, and 6 of the Constitution, but it's also a violation of one's constitutional rights to be free from cruel, inhuman, and degrading treatment under Articles 29F and 25A. The rights to a fair trial under Article 51 and 2 and 25C. The doctrine of the separation of powers, articulated in chapters 9, 10, and 11 of the Constitution, and the authority and independence of the judiciary under Articles 159 and 160. Citing the cases of Attorney General against Kigula and quite a number of others, the rest of the submissions of counsel for the Amicus Curiae echoed those presented for the petitioner that the mandatory death sentence robbed the offender of an opportunity for an individualized sentence that took into consideration factors relating to the offender, prohibits the offender from presenting mitigating evidence to the court, thereby depriving the offender of his right to a fair trial under Article 25C of the Constitution, and that, contrary to the doctrine of the separation of powers, it prevents the court from exercising its discretion in sentencing, thus leaving it to Parliament to control sentences in all murder cases. On damages, the Amicus Curiae asserted that even though their trial had been concluded and death sentences were imposed upon them under the former Constitution, the appellant's petitions addressed a continuing violation of their fundamental rights and were therefore entitled to a remedy for a breach of their constitutional rights. As regards the commutation of the petitioner's sentences to life imprisonment, the Amicus submitted that did not affect their entitlement to challenge the constitutionality of the mandatory death sentence imposed upon them. They urged this court to find that only a lawful sentence could be commuted. In conclusion, the Amicus Curiae urged this court to be guided by experience from other jurisdictions, especially Uganda and Malawi, where the mandatory death penalty has most recently been abolished, and declare the mandatory nature of the life sentence under Section 204 of the Penal Code unconstitutional, and remit the matter to the High Court for resentencing. The Attorney General relied on his written submissions dated the 25th of March 2016 and submitted that under Section 71(1) of the repealed Constitution, the mandatory death sentence was, at the time it was imposed on the petitioners, expressly legal and constitutional. He, however, asserted that under the current Constitution, it is constitutional not because it is cruel, inhuman, and degrading, but because it compromised it is unconstitutional, not because it is cruel, inhuman, and degrading, but because it compromised the right to a fair trial. That being the case, and since the current Constitution has no retrospective application, the Attorney General urged that the petitioners were not entitled to challenge the constitutionality of the mandatory death penalty. At any rate, he further submitted, the death sentence having been commuted to life imprisonment by the President, It was Otio's to challenge its legality. He therefore dismissed the petitioner's case, their prayer that the matter be referred back to the High Court for his sentencing. Thank you very much, Mr. Chair.
My sister Judge Njoki will take it from here.
Having considered all the pleadings, written and oral submissions of the parties, we find the following issues arising for determination. A, whether the mandatory nature of the death penalty provided for in the Penal Code under Section 204 is unconstitutional. 2, whether the indeterminate life sentence should be declared unconstitutional. 3, whether this court can or should define the parameters of a life sentence. And finally, what remedies, if any, accrue to the petitioners. I will address the first two issues for determination, and my senior sister, the DCJ, will address the other two. We wish to make it clear from the onset that we decline to consider the wider issues raised by the Amicus curiae in relation to the issues of constitutionality of the death sentence and an accompanying interpretation of Article 26 of the Constitution for the simple reason that they did not arise in this appeal. As stated at the onset of this judgment, the constitutionality of the mandatory nature of the death penalty has engaged many courts in various jurisdictions globally. It is the major issue in this appeal. It has also engaged the High Court and the Court of Appeal in many cases in this country, resulting in divergent opinions. It started with the Motiso case under the repeal constitution, in which the Court of Appeal opined that as it denied an accused person the right to a fair trial, the mandatory death sentence was arbitrary and unconstitutional. That remained the position until the Moura case, in which the Court of Appeal changed its holding that by the use of word shall, Section 204 of the Penal Code was couched in mandatory terms, leaving the court with no discretion but to impose the death penalty. Though some High Court judges have questioned the propriety of the Moura decision, they nonetheless deferred to the doctrine of stare decisis and followed it. The overarching position flowing from the Moura case is that the couching of Section 204 of the Penal Code with the mandatory word shall gives trial judges no option or discretion to mete out any other sentence save the death penalty. On the international arena, however, most jurisdictions have declared not only the mandatory but also the discretionary death penalty unconstitutional. We have laid out a number of cases which we have looked at from the United States. We've also looked at two Indian decisions, which I think are important, and we've also looked at a number of cases by the UN Human Rights Committee. In light of this background, it falls upon this court to bring clarity and to make a determination as to whether the mandatory nature of the death penalty under Section 204 of the Penal Code meets the constitutional standard. The section categorically states, quote, any person convicted of murder shall be sentenced to death. To determine the matter, it is imperative to consider certain constitutional provisions in relation to the provisions of the Penal Code. Article 19 of the Constitution provides that the rights and fundamental freedoms in the Bill of Rights belong to each and every individual and are not granted by the state. Article 20, subsection 2, states that every person shall enjoy this right and fundamental freedoms to the greatest extent consistent with the nature of the right or fundamental freedom. Article 28 of our Constitution also provides that a person has inherent dignity and the right to have that dignity protected. Article 48 mandates that the state shall ensure justice for all persons. The rights of an accused person to a fair trial is provided for under Article 52 of the Constitution. This right is absolute, as it is one of the rights which cannot be limited pursuant to Article 25 of the Constitution. It states in part, quote, "Every person has a right to have a dispute that can be resolved by the application of law decided in a fair and public hearing before a court or, if appropriate, another independent or impartial tribunal or body. Every person has the right to a fair trial, which includes the right, if convicted, to appeal to or apply for review by a higher court as prescribed by law." Kenya is also a signatory to the International Covenant on Civil and Political